I often wonder, while standing online to get into a federal court or Yankee Stadium or on a plane, whether any sensible person really thinks that the conflict between the things that we want to do and the security that we need to be able to do them is a false choice. I dare say that most people view choices as a matter of common sense and an inevitable part of life. To make choices is often hard, calling for maturity and judgment. To deny that they have to be made is irrational. It's not a matter of choosing between, for example, our security and our values. Our security is one of our values, the one that makes the liberties that we cherish something more than a parchment promise. The difficulty, of course, is that our values don't live in a vacuum. They conflict and they compete. Even vital ones, as to which everyone concedes the importance, are overcome by values of greater significance. This is especially so when a cherished individual interest collides with a value that is critical to the life of our society, critical to the arrangements a society such as ours must have in order to thrive. And that, I think, is the essence of the libel tourism debate. I don't think anyone in his right mind would contend that reputation is something that we regard as frivolous. Reputation is something that is valued in a weighty way, a person's good reputation. And it is a critical value. We do honor reputation under our law. Our law protects it as it should with defamation actions. But reputation is a value. It's not an absolute. And it would be preposterous to say that the value that we place on reputation is not in tension with the value a functioning Republican democracy places on the free exchange of information, especially on matters of great public importance. It would also be preposterous to say that to acknowledge and attempt to resolve this tension is to make a false choice. The choice our society has made is to give the free exchange of information, the so-called marketplace of ideas, precedence over concerns about reputation. Under U.S. law, enshrined in our First Amendment, journalists have a right to be wrong. The journalist has a minimal obligation of diligence. Truth is a defense to an allegation of libel, but the journalist need not prove it. The burden is on the person claiming he has been defamed to show that the journalist is not only wrong, but especially in the case of a public figure, maliciously or recklessly false. The rest of the world, including our good friends and forebears in the United Kingdom, do not adhere to these enlightened standards, and that's their choice. But we do, and we not only adhere to them, we consider them to be in the pantheon of fundamental rights that we've agreed to be governed by. And for good reason. We're a self-determining people. Government is formed to serve us, not the other way around. If information cannot be freely exchanged, if journalists must fear being sued over information reported in good faith on matters as crucial to our defense as the financial support networks of radical Islam, then we can't make sound security policy. We become dependent on government in all its dysfunction and all its political correctness, with no means to evaluate its performance or to induce it to change. We become reliant on government for our information, and in fact, we are hamstrung in learning even what little government is willing to reveal. Rachel Ehrenfeld's book, for example, which is at the heart, I think, of the libel tourism debate, largely repeated allegations about Saudi terror financing that had been made in official U.S. government documents and testimony. Sheikh Khalid bin Mahfouz's suit targeted her anyway. And under British law, it was not enough for Rachel Ehrenfeld to say, I'm just repeating what the United States government has already said. She was expected to prove that it was true, even though as a journalist, she had no access to classified information and no subpoena power to compel government officials to come forward and verify what she had said. In the limited time I have left, let me just make a couple of final points. First, it's argued that the international order calls for comity between nations, that the U.S. should not force its standards on other countries. But libel tourism laws do not force any nation to adopt our First Amendment. They merely say that if you want to enforce a libel judgment against an American in the United States, you must extend that American the equivalent of First Amendment protection. If you don't, You still have your judgment, and you can enforce it anywhere on the planet where they're honoring it. You just can't enforce it here. Moreover, the proposal for an affirmative cause of action against litigants like bin Mahfouz, who would scheme to suppress American First Amendment rights, do not coerce any country to either adopt or enforce our libel law. It would simply tell the libel tourist, if you scheme to deprive Americans of a fundamental constitutional right, you can no longer do it with impunity. We will arm Americans with reciprocal power to sue you for damages in a court far from your home, albeit one that will surely give you a better shape than U.S. journalists have gotten in the British court that has become known as the Club Med for libel tourists. Finally, comity among governments is all well and good. I certainly wouldn't want to do or say anything that would spoil a good State Department cocktail party. But as it relates to the rest of the world, the primary duty of the United States government is to protect the fundamental liberties of the American people, even if doing so occasionally miffs the international community. That's not a false choice, but I think it's the only right choice. Thank you.
As I expect, I'm sort of the lone dissenting voice, which may be explained by my background in the law that I practice. I've been representing libel plaintiffs and claimants and people who have general beefs with the media for about 30 years now. I can tell you that if there is a chilling effect coming in from overseas or from anywhere else, sources in the United States, I haven't seen it in the 30 years I've been representing people who come to me with things that are written or put on television about them. I think that's an overplayed concept. I think that the protection of speech in the United States is, in fact, as Andy describes it, about as good as it could be for the media. Not so good for the people who are injured by the media. Now, Andy gave a vow to the value of reputation. I'd like to add a little something to that so that you can think about the fact that this is something that every individual on the planet carries. This is by Potter Stewart, late Justice of the Supreme Court. You may remember him for his very famous dictum that he didn't know how to define obscenity, but he sure knew it when he saw it. He had another bit of sage advice in a case called Rosenblatt versus Baer, back in the sort of the formative days after New York Times versus Sullivan, when the Supreme Court was struggling, as it might once again start to struggle with exactly how do we treat defamation here in the United States. He spoke of reputation in these terms: the right to protect a good name through the law reflects no more than our basic concept of the essential dignity and worth of every human being, a concept at the root of any decent system of ordered liberty. That is not a minimal value in my judgment, and it's the value I try to protect in my work. I've been an opponent of libel tourism laws in the state where Dr. Ehrenfeld led the charge, my own state, New York. I expect to be opposing the efforts to pass even more draconian laws in the Congress of the United States, something that's probably going to come up this year. And California is also considering a similar bill to that passed already in New York. I oppose these laws not only because one of these days I may get a client from the UK or Canada or Australia who wants to enforce a judgment over here. I know a lot about the history of enforcement of those judgments, and I can tell you, and I bet most of you know this already, there has never been a successful enforcement yet of a English or other foreign court libel judgment in the United States since New York Times versus Sullivan and the cases following it have been the law of the land. They've all been defeated on the basis of the public policy exception to the laws that govern recognition of foreign judgments. A lot of you will think that's as it should be. My problem with the libel tourism laws as proposed, and with the decisions that have been made already in those cases where the American was able to resist enforcement successfully, is that they're based on a simple comparative law test, that our system is more protective than it is in the UK or Canada, Australia, Ireland, and so forth, and therefore you can't enforce it. My view is that there are meritorious cases that are brought in other. For instance, the major theme of this conference is Islamic terrorism. If there is a weapon that's been discerned to use libel in the campaigns of that nature, that's something clearly that has to be dealt with. But the laws that are proposed don't just purport to affect the enforcement of a law brought by an Islamist. They ban every libel judgment in any foreign court that's brought to the United States. To my mind, that has enormous potential for disrupting international comity, that mutual respect between countries, particularly with your friendly allies. It has enormous mischief-making capability for retaliation. If we don't enforce judgments from England, France, Canada, and so forth in the defamation area, what's to stop them from enforcing judgments when Americans bring them over to England or France or Germany? Not just in speech matters, but in commercial matters. Are we going to set off a round of mutual retaliation and recrimination? I want you to think about the fact that very prestigious institutions, such as the American Law Institute and the National Conference of Commissioners on Uniform State Laws, have put enormous time, decades of time, into pushing laws that provide for mutual respect between the judicial systems of friendly countries, countries with civilized, basic norm systems. And these laws are putting that in jeopardy. It's a case of, I think, throwing out the baby with the bathwater. If there's a problem having to do with the Sheikh Mahfouzes of the world, that doesn't mean that some businessman in England who has been libeled by a newspaper, God forbid it should be the Wall Street Journal, can't come over here and collect his judgment. That's simple justice, and it ought to be recognized by all nations of the world. There are many other reasons why I think these laws should be challenged. For one thing, they ground jurisdiction, personal jurisdiction over foreign residents on a concept that the mere bringing of a suit in their own country or in a country where they can establish jurisdiction and a reputation, and the mere service of papers giving notice to the person over here is enough for personal jurisdiction. That's a very advanced concept. In fact, one of your moderators for this afternoon, Mr. Rifkin, has an article in, I believe, the Wall Street Journal, which he says that's a very dubious proposition from the point of view of due process. I agree with that. I think these laws are not well grounded in due process, that the idea of a damages action against a person who has a temerity to sue an American is a very bad idea, and it's simply going to end up with that foreign defendant doing exactly what Rachel Ehrenfeld did. Ignore the case over here, and then fight it if someone takes it over to their country to attempt to enforce that American judgment, in which case it's going to get the boot from that country. Thank you.
I'd like to open it to the panelists to respond to each other.
Just a couple of responses, particularly to point isn't whether you can get libel judgments enforced in the United States. The point is the intimidating effect of having the judgment, which is why Mahfouz seeks it in the first place. This is a guy, frankly, who's worth $3 or $4 billion. Having a $200,000 judgment against Rachel Ehrenfeld wouldn't get him through a day. The point of having the judgment is not to collect and enforce the judgment. It is to have the interorum effect of the judgment in order to intimidate people who might publish or sponsor someone like Ehrenfeld's work. Secondly, I think what we're talking here is about speech cases. Speech is a particularly important value in the United States. That's why it's enshrined in the First Amendment. I don't think it's reasonable to think that if we take action in speech cases that would prompt a round of refusals to enforce judgment in all kinds of other matters. But even if it did prompt an argument about that, it's an argument worth having over American free speech rights because they are critical to the functioning of our democracy. Finally, let me just respond to the point about the thought that jurisdiction would attach or be created merely because of the bringing of a lawsuit. Rachel Ehrenfeld was hauled into court in England on the basis of the purchase of 29 copies of her book over the internet, evidently, in a place where she didn't try to market the book. If that is a thread that jurisdiction on something as critical as this can be built, I certainly think it's worth exploring how expansive we can make jurisdiction for a retaliatory action. And mind you, what we're talking about in terms of that action is not an American affirmative lawsuit in every case, but only where somebody can prove a claim that there's actually a scheme underfoot to suppress American personal rights.
Thank you. I'd like to respond to before Mr. Walsh. I'm sorry.
Just a quick one. The problem of jurisdiction is paramount here. I think Andy's glossing over it. In terms of constitutional points, we're talking about free speech as a constitutional point, but due process and the jurisdiction of our courts is also one of the bedrocks of our Constitution, and those values have to be honored. No court in the land that I know of, including the adventurous Ninth Circuit Court of Appeals, has gone as far as these statutes would permit. You can't create jurisdiction by simply reciting in a law that jurisdiction is established against a person who brings a lawsuit against a United States person in a foreign court, a defamation lawsuit, and serves papers in the United States. That's what the Senate and related House bill, I think, purport to do in terms of establishing jurisdiction. I think if those laws pass, maybe it has to be tested. I think I hear Andy saying that, yes, we should try and get it tested. But I think that lawsuit's going to get thrown out on the first go-round.
Any more on this topic?
Yeah, I have a question for John. I'm kind of undecided about this, these libel tourism laws, and you answered a question that I had in thinking about them, which is, do any of these judgments ever get enforced? You said no, they haven't been enforced since New York Times versus Sullivan. And so this would lead me to think, well, maybe these laws are superfluous and there's no need for them. But if judgments such as these haven't been enforced in 45 years, what difference does it make if we pass a law saying they're not going to be enforced henceforth? Why should we fear that there are going to be all sorts of terrible reactions from other countries?
My point's a little different, James. The attempts to enforce have been a couple famous in New York. There was a judgment obtained by an Indian national in a libel case, Bakshan versus India Abroad. He brought it over here, and the New York court, on a motion to dismiss or deny enforcement, simply said that judgment was arrived at in a libel. It doesn't we are going to enforce it on public policy, etc. when they have been brought, the Constitution has worked for people who have sought to deny enforcement. If the Constitution works, why do you need a statute? And particularly a statute that basically at its heart says to our friendly neighbors across the pond that you're operating a rotten court system. This is the place that gave us our defamation law, somewhat improved upon by Justice Brennan in the New York Times versus Sullivan in 1964. It's established here. I don't think it's going to change. That doesn't mean that the Brits don't have a decent system of getting at truth and finding out whether there's been irresponsible publication. And I should note in this regard that they are even advancing towards our New York Times versus Sullivan standards in cases involving questions of public interest and whether or not the journalism that reports it is responsible or not. And that's been reaffirmed in a case in which James's employer was the defendant and has moved England, and I think other countries in the UK will follow a long way towards our standards.
I don't think they go far enough. I don't like the idea that somebody like Ehrenfeld or anybody else who did the right thing, who did the absolutely right thing, is banded somehow a fugitive and told in no uncertain terms that although the United States won't enforce these judgments, you can't travel to England, there, you might be able to go somewhere else, but not to another place. It reminds me of the absurd photograph of General Allan war crimes. That's not the way to run a civilized world. I quite literally made a well-publicized trip to Italy, in which I challenged the Italian authorities to confront me. There, somehow saying, all right, I'm sorry, there's a judgment against me, but ha-ha, you can't enforce it here because I'm a fugitive, I'm not coming. We ought to behave like law-abiding people. If there is a judgment against me, I will challenge the judgment where it took place. Which leads me to, I think, Mr. Gaffney's point about sovereignty. Harold Close, a friend of mine, and I disagree with many things that he says and does, but agree with many others. I think sovereignty and the attack on sovereignty is a two-edged sword. I think we ought to do more as a country to persuade the world that our view of freedom of speech is the right one. We ought to be much more active in United Nations bodies and other places instead of fighting against what the Sharia attempts have been to try to make us feel guilty that we're going to tolerate hate speech against Islam. We have to do more to export our theory of freedom of speech. We've done a little bit of that, as you say, in Great Britain. Truth is now a defense. Used to be the law, not only in Great Britain, but in the United States, that truth was an aggravating factor. If the libel was true, that makes it even more damaging and dangerous than if it was false. That's actually a statement from the John Peter Zenger case back in the United States, and other opinions. It took us a long time to get our views of truth being established, and the views that I was honored. I was a law clerk in 1964 and worked on New York Times versus Sullivan, one of the great honors of my life to have worked on Justice Goldberg's concurrence in that case. We have to export our theory. We shouldn't be satisfied simply by saying it's not enforceable in the United States. We want people who express these kinds of views to be recognized around the world as having done the right thing, having contributed to market ideas, having done things that are good not only for the United States, but for Great Britain. We have to persuade Great Britain that they are wrong, that Italy is wrong, and France is wrong, and maybe even to the point, here again, I think Mr. Gaffney and I might disagree. I think the United States government should enter appearances in cases involving restrictions on freedom of speech in the United States of America. They ought to try to become a party to those lawsuits. Because remember that the First Amendment is not designed to give the Speaker the right to express his views. It's designed to give the listener the right to hear those views. It is part of a marketplace of ideas, and and the United States has to try to enforce that open marketplace by taking a far more proactive role in defending the substance of the right, not just the procedural aspects of how we enforce them.
And so, if you are convicted and sentenced to 7 years?
No, I will take it to I will not try to get it unenforced in the United States. I will take the case up to the again, Mr. Gaffney and I might disagree. I will take the case up to the European Court of Human Rights and will challenge it within that system and try to establish a precedent. I'll take it to the Italian Supreme Court, and I'm confident I will win. I think this is an idea whose time has come. Now, there is an international, as you know, the International Court in Strasbourg has written some very good opinions. There was a case involving a newspaper in the Czech Republic, which was very critical of a judge, and a criminal contempt was filed against them. And the International Court said, no, in Europe, Europe, of course, is an abdication of sovereignty by the countries of Europe to an international court. There is a right of free speech and a right to criticize judges. So I would prefer to see this fight fought on a more substantive basis, or at least in addition, on a substantive basis, in addition to just the procedural aspects of that.
Well, at the risk of agreeing with I certainly am for fighting and for being as assertive as we can of our sovereignty. I just don't want him to be under any illusion that the jurisprudence that he's prepared to submit himself to, and I commend him for his courage in doing so, is a rigged game. It is certainly true that on some matters the European Union has defended free speech, but I think the point that I was trying to get at is, and I would say this to my friend James Taranto as well, that makes this less of a certitude than he would have Brooke feel about being able to have this conference a year from now, let alone 10 years from now, even in this country, is the people who are trying to suppress free speech, the people who are using these various international mechanisms, the transnationalists, if you will, on the secular side, about which we will be hearing much more after lunch today, are backed by something that not even the Nazis in America, in their heyday, were able to bring to bear, which is fear. And that fear is changing the face of Europe today. It is changing the face of these international organizations today. I want to, if I may, just recognize one of our valued colleagues, Patrick Subdeo, who's, I think, in the back of the room, if I'm not mistaken. Patrick, would you mind just standing and being acknowledged? Patrick's Westminster Institute has done a terrific paper, of which I think there are copies outside, which I would commend to you, on some of the things that he's witnessing and documenting in terms of the application of fear in ways that are mutating freedom of speech such that I don't think there's a snowball's chance in hell, with all due respect. That even so capable an advocate as Allan Dershowitz, who would presumably have no fool for a client, would find himself suffering at the hands of people whose thinking about jurisprudence, thinking about the application of freedom of speech, thinking about some of the very most basic principles, not only of Europe, but of the Universal Declaration of Human Rights, are no longer able to apply it as was originally crafted in the intent. And that is what is coming here, ladies and gentlemen. The United States Congress, and James sort of dismissed this, but the United States House of Representatives, just 2 or 3 weeks ago, adopted hate crimes legislation. Now, at the moment, it seems to be mostly aimed at protecting pedophiles and unsavory characters, but you can bet that a president says we must use respectful language when talking about Islam. A president who is going to go to Al-Azhar and speak to the Muslim world in, I am quite certain, very respectful language, is a man who would be very comfortable seeing this same kind of deference paid, this same kind of accommodation made, so as not to give offense in the name of freedom of speech. And so I fear that these rather more sanguine comments, they remind me a little bit of the guy who, having fallen off a 50-story building at the 30th floor, asks, how's he doing? And says he's fine. Well, he is at the moment, but it's not necessarily a prediction of how he will be doing. And I don't think that these, as I say, rather sanguine comments are a prediction of how we'll be doing if we're not careful.
I'd like to respond to that. First of all, I would like to disassociate myself from the idea that we should not use respectful language when talking about Islam. I don't see anything wrong with using respectful language when talking about a major world religion and the religion of a substantial minority of Americans. We can criticize it all we want. We can use very harsh language in describing the extreme elements of it, but I agree with the president on that. We should use respectful language. The hate crime legislation...
I'm afraid you can't do both. You can criticize it, and you can point out its hateful aspects, and be respectful. That's sort of the point.
I think we'll have to respectfully agree to disagree on that. The hate crime legislation that the House passed contains a rule of construction that says, quote, nothing in this act or the amendments made by this act shall be construed to prohibit any expressive conduct protected from legal prohibition by or any activities protected by the Constitution. If it didn't have this rule of construction and it were construed in that way, it would be overturned by the Supreme Court in a second. And the court has made the distinction between hate crime laws, which are constitutional, and hate speech laws, which are not. You can give somebody a harsher penalty for choosing a victim on the basis of his membership in a group. I have difficulty with that concept, and I have problems, other problems with this law. I'm not endorsing this law, but it's not a threat to free speech.
May I just comment on that briefly? As someone who often engages in speech which is deemed to be disrespectful, clearly it's very important that we protect disrespectful speech as well, because respect and disrespect is in the eye of the beholder, and we always need what the Talmud talks about, a fence around the law. We always need to err on the side, as Justice Brennan repeatedly said, of protecting bad speech in order to make sure that there's good speech that's protected. But having said that, I do want to make an important point. This is a painful point for me to make, but with regard to Mr. Gaffney, I think there's an enormous difference between prohibitions on free speech and what Mr. Gaffney spent maybe 2 minutes on, or Sharia-compliant finance laws. Maybe I'm ignorant. I favor that Sharia compliance finance rules. That's an accommodation with religion. To me, that's like kosher laws that we have now and try to push all over the world. We want the world to be a safe place for kashrut laws. Yes, it's a little bit expensive. And when you read the Holocaust denial websites, as I do, kosher laws are always described as the kosher tax. I believe in accommodation between religion. I've actually helped, in a couple of cases, people who want to borrow money and can't do it for purposes of interest. Now, I may be ignorant about this, and there may be things about it that are very dangerous and damning, but the concept itself of trying to make the world, the international financial community, a place in which members of the Islamic faith who don't believe in interest can invest, I can't see that as a threat to freedom or as anything more than an accommodation to religion. So it's really part of what we said before, what Mr. Turner said, respect for religion. I want to make a sharp distinction between the religion itself, even the rules of the religion that I might fundamentally disagree with, and those aspects of the religion that go beyond and transcend. I mean, no Jew would ever say, I hope, to a non-Jew, I'm offended if you eat pork. That's not part of the Jewish tradition, yet Islam says they are offended if a non-Muslim eats pork, or they are offended if a non-Muslim shows a portrayal of Muhammad. We have to stop that. That's wrong. But unless this Islamic compliant finance imposes restrictions on the way we do our finance, and it may be, and I may be just unfamiliar with that, the sniff of what I'm hearing, jumbling together restrictions on free speech with restrictions on finance is something which is deeply troubling to me.
If I can just add,
Just briefly respond, since I've been directly taken on here. I hate to take advantage of the acknowledged ignorance, Mr. Dershowitz, but in point of fact, the reason I brought it up was not to deviate from the purpose of this excellent panel, but to amplify that the problem with Sharia is fundamental. It is a world program aimed at the imposition of that global theocracy that I talked about. And so whether it is Sharia blasphemy laws that are being imposed as a way of forcing us all to submit, I think as you've acknowledged, or whether it is what some of its proponents call financial jihad, Sharia compliant finance. These are instruments for bringing about not simply an accommodation on the part of a non-Muslim society of the legitimate religious practices of a minority. It is about building parallel societies. It is about insinuating into free societies, non-Muslim societies, arrangements that ultimately will force the non-adherent community to submit. And I think this is a subject that I would love to participate in your education on, if I may. And I'd also introduce one of my colleagues, David Yerushalmi, who is the world's leading expert on the subject of Sharia finance, and has really, I think, distilled to its essence why this, like Sharia blasphemy laws, and indeed all other Sharia accommodations, in a society like ours, with a constitution like ours, separating church and state, not accommodating religion to the point where it becomes a political and indeed seditious agenda.
I remain unconvinced by your education, but I'd like to continue the conversation. Mr. Chairman.
I just wanted to echo what Allan said earlier about that disrespectful speech should be protected. It is protected. And I just want to underscore that there's a big difference between the president in his hortatory role telling us that we ought to speak respectfully, and that this does not imply that we should be punished for speaking disrespectfully or required to speak respectfully, which of course I would be completely against, and the Constitution would too.
Anything more?
I just want to leave on that point for just a moment, because I feel like the discussion on each side of me is sort of like two ships passing in the night. I too think that there's no point in speaking disrespectfully about Islam. And I would promote the idea of speaking respectfully about Islam. But I think what we mean by that is that we should be objectively respectful. We shouldn't govern ourselves in accordance with what the subjective perceptions of whether we're being adequately respectful or not are in the Islamic community. I think that we should ourselves make an effort to speak respectfully. Back in, I guess, 1993, when we issued our indictment in the blind sheikh case, we called the case United States against Rahman, which was the practice in the district. You used the defendant's last name. We were told that that was taken by people in the Muslim community to be offensive, because what it meant to them was to say United States versus God. And I was a pretty aggressive prosecutor, but that was not the case they really wanted to do. But the accommodation we were asked to make was simply to acknowledge Dr. Abdul Rahman's name, Abdel Rahman, which meant servant of God or soldier of God. And it didn't seem to us to be a terribly demanding accommodation. It didn't reduce by a whit the aggressiveness that we argued the case with. It certainly didn't minimize anything that we accused him of, or the force that we tried to prove the case with. But it was an accommodation to try to be, respectful and cognizant of the feelings of people who I didn't see any point in gratuitously offending. I still feel that way. And I just think we can bridge what I take to be kind of a senseless disagreement.
Can I just make one brief response, and that is this. Roman Haruska once famously said that even the mediocre deserve to be on the Supreme Court. Even the ignorant deserve to be listened to. And it's my ignorance that's a very important point. That is, the fact that I don't understand the case against Sharia-compliant financing means that you haven't made the case very effectively. It means that it sounds like you're lumping together a range of issues that are legitimate. That is, Sharia people should be allowed to have their own financing, with a very different case, which you seem to be suggesting now, and that is a case that they're trying to impose their way of financing. You have to persuade ignorant people like me and others who may be even more ignorant out there reading the paper how this is different from the kashrut laws, the Jewish marriage and divorce laws, and other attempts to accommodate which we in the Jewish community press for when it comes to our religion. It's very important that you make the point distinguishing the positive and the negative. This is part of the respectful attitude toward Islam, that we can't just have a frontal attack on everything Islamic, including finance. We have to have the most refined distinctions where it is permissible and where it's impermissible. And that case, I'm sorry to say, has not been made sufficiently to educate me and others like me.
I hope very much that this esteemed organization will convene a new conference shortly on Sharia finance, and that we have an opportunity to lay this out. Let me just make 2 points quickly. This isn't about respect or disrespect. The Islamists would have you believe that essentially anything said about them, about their prophet, about their God, about their practices, is by definition disrespectful. No matter how accurate it is. As was mentioned a moment ago, Rachel Ehrenfeld was brought up on charges for citing U.S. government documents and findings. Well, in much the same way, you can be brought up on charges, according to this notion of disrespect, for citing the Quran itself, for citing the hadiths, for citing the traditions, for citing the practices which have been brought together in the form of Sharia. And to talk about Sharia honestly and accurately, as the authorities of Islam itself do, is said by them to be disrespectful because you're doing it. When they do it, it's just dawah. It's just the practice of their faith. And in the eyes of many, and increasingly now, it's being accommodated. In fact, it's being internalized, in your friend Harold Koh's form of expression, into Western law, that you can't do that. If it gives offense, you can't do that. And that is why, as we will talk more about this afternoon, I'm sure, we're seeing this constriction of freedom of speech. Not because people want to be offensive to Islam, not because people want to be objectively, as my friend Andy says, objectively respectful, but because they're being accurate, because they're talking about a program that has at its core, whether it's in the financial dimension, whether it is in the military dimension, whether it is in the political dimension, whether it is in the religious practice dimension. It has at its core a supremacist program. And you cannot take any of this out of that supremacist program and understand what it's about, let alone be accurate in describing it. And yet you will give offense, I guarantee you, You will give offense to anybody of that Sharia adherent stripe by so doing. So we should be under no illusion here, folks. This is not going to go down easily. We will either stand up for the rights that you have so brilliantly articulated on so many occasions now, and we will resist this pressure, or we will accommodate to it. And I believe that when the President of the United States uses this term, respectful language, it is in the context of many other things he is saying and doing, and we will see them on display in Cairo next month, that constitute submission.
Closing last
I'd just like to bring us back to libel tourism legislation. And offer perhaps a way out of the problem. We're in the internet age. It has turned everything, all of our notions about publication, where information is published, upside down. A book published in America on Monday can have just about all of it around the world, and particularly to countries where the subjects of the book are resident or do business and so forth. I think perhaps rather than have 200 different countries' interpretations of law to deal with that, nations really do need to get together and decide at least how we handle internet publication. I think there needs to be an international convention of some sort that will set standards for dealing with defamation by internet, which might also lead to the bridging of the gap, at least between the countries of the West in terms of how we deal with subjects of public interest and whether responsible journalism or writing has been practiced. This is the question of where information lands up and who it informs and who it hurts is something that is a paramount issue for our time.
Thank you very much for, I think, for most interesting discussion.